All right, this panel is composed of Judge Cloyce to my right, Judge Torpey to my left, and myself. And we're ready for the Rivers versus State case. This is a criminal case, 15 minutes per side. And appellant, if you will tell me whether you wish to reserve any time for rebuttal, I'll try to remind you of it.
Good morning. May it please the Court, Paula Kaufman on behalf of the appellant GODDU Rivers. I would like to reserve 3 minutes for rebuttal. The appellant will concede this morning that even a prostitute can be raped. The critical question in this case is whether this one was. And the problem is...
Was a prostitute or was raped?
Whether this prostitute was raped.
Well, let me add, the theory of defense here was one of consent. Is that right?
Yes, sir.
So just going from that, the inference is that if she was a prostitute, she consented to the sex. With me so far? If she was a prostitute, there's an inference that she consented to it. Is that the theory, or am I wrong on that?
The analysis boils down to my client got stabbed. Now, there are two possible reasonable explanations for that. Either the victim just got raped and he got what he deserved, or the prostitute didn't get paid.
I understand. That's the theory. The theory is that it was consensual sex, and she was motivated because of some dispute that they had during this transaction,
yes,
right?
Okay. And the problem is that evidence that we believe would have persuaded a jury, would have tipped the scales overwhelmingly to support the conclusion that this victim was a prostitute, the jury never got to hear.
Okay, but you're trying to prove that she was a prostitute, or that she was engaged in prostitution on this particular occasion, right?
Yes, sir.
Okay. And, of course, your client offered direct proof of that.
Which was characterized as his self-serving assertion.
Right, and you wanted to bulwark that with the evidence that she had been previously arrested.
Yes, sir, but it's more than that. It's not just evidence of a prior arrest. It's
well, let's take that.
Explanation.
Let's start with evidence of a prior arrest. Is there any scenario in which evidence of a prior arrest can be offered into evidence to prove that a person acted in conformity with that prior behavior?
I think because this part of this woman's statement involved an explanation for that prior arrest, and that story was, to be polite about it, preposterous. That made it relevant in this case. It's a part of full and fair presentation of the defendant's defense. It's a part of full and fair cross-examination of the key prosecution witness in this case.
All right, just setting aside for a minute the conversation with the police officer, do you acknowledge that as a general proposition that if you're trying to prove that a person committed a particular act, that you cannot introduce evidence of a prior arrest for a similar act?
Yes, sir. And the erroneous decision that got made in this case was predicated on the idea that only an alleged rape victim's conviction for prostitution is relevant to her credibility. But that's just not true in this case. The Constitution got trumped by the evidence code. The rape shield statute was used by the prosecutor in this case as a shield to argue...
Well, the rape shield statute's not relevant here. The trial judge relied on the wrong statute. This is just an issue of evidence, right? If the fact you're trying to prove is that she was engaged in an act of prostitution, as a general proposition, you cannot establish that fact by proof of a prior arrest for similar conduct. Isn't that just a pretty fundamental rule of evidence?
Yes, it is.
In other words, if your client was charged with sexual battery, the government would not have been able to introduce the fact that he had been arrested 20 times previously for sexual battery in order to prove that he acted in conformity with that prior behavior.
I agree, Judge, but this is so much more than prior bad act evidence. It's really her statement about the res gestae of this incident. Mm-hmm. And I would point out that very little of what this victim had to say was believed by this jury. He was acquitted of 2 out of 3 counts. It finally came down to the circumstance of that that contact of sexual intercourse and whether that contact was consensual or not.
Let me ask you about I'm sorry, go ahead, Judge.
Go ahead and finish your question.
The conversation with the police officer had to do with the prior arrest for prostitution and her explanation for that. Is that right?
Yes, sir. If I could go into that a little bit because it's so important. This detective very quickly picked up on the suspicious circumstances of this incident. This woman was on foot with not even a dime to her name at almost midnight on a Sunday night in a not too great section of the trail. She admits when she gives her statement, well, I was over at this hotel hanging out with my friend Rodelli or Rondelli with an I or a Y depending upon which portion of the record you're reading, and I don't know whether that's attributable to the court reporter or to the victim's story, but she's hanging out with this prostitute. She claims her boyfriend doesn't come to get her, and about 11 o'clock she decides to walk to her hotel. She admits to the detective that she's stopped by no fewer than 3 what I would call potential Johns, and she doesn't ride with them because they look creepy to her. When asked by the detective, how do you know this mysterious Rondelli prostitute friend of yours is a prostitute? This is her explanation. She says, I was arrested for prostitution. I've been involved with the system, but it was all a big misunderstanding. You see, I look a lot like my friend, this prostitute Rondelli, and what that has to do with it, I'm not sure, because the paperwork in the record indicates that this woman, this alleged victim in this case, was actually negotiating a deal with an undercover officer, and her explanation to the detective in my case is that she was actually brokering a deal for this
Well, she was never charged.
mysterious Rondelli.
But she was never charged.
Counsel, the troubling thing to me is that we review these decisions on the basis of an abuse of discretion. And while I might, as a circuit judge, agree with your position at the trial, you've got to demonstrate to me that no other reasonable circuit judge would do that. And maybe Judge Monaco might, or maybe Judge Torpy might, or maybe some other circuit judge might. It's one of these close call situations where I just am troubled by us reviewing and overturning a circuit judge on an abuse of discretion in light of the fact that there was simply testimony that she had been arrested but never charged. If she had been charged, or she had had a trial, or if she had been convicted, I think your argument would be a slam dunk, but I'm just troubled by it. Maybe you can comment on it.
Well, my recollection, and I wrote in my notes here that this was a null pros. The court may be correct, and I apologize if I'm in error. I didn't realize that a no bill or a null pros to this very moment. I did not realize that that means that the suspect did not do what they were arrested for. My understanding is...
Does it make you think that they did?
Well, my understanding as a former prosecutor...
Isn't that the whole idea?
My understanding as a former prosecutor and as a defense attorney for the last decade is that a no bill or a null pros means either the state thinks they can't prove the allegation or that for some reason they don't want to bother to. There is no evidence in this record to explain why the state did not go forward with this charge. Now, the state is going to argue before Your Honors this morning that actually, had all of this come out, this would have simply bolstered the prosecution's case against my client because it would have shown that this woman, in fact, isn't a prostitute. I would point out that in her statement to this detective, and this is at page 78 of the record, she admits to this detective, yeah, I was once a working girl, but I don't need that anymore. I have a job now, even though she had not been paid for the last 2 weeks, was living in a hotel because she could not afford an apartment, had a 5 or 6 year old child to support, and couldn't even afford bus or cab fare.
Let's stay focused on what the errors were that the trial judge committed. One was that he did not let you introduce evidence of the prior arrest, and we've already spoken about that. Second was he didn't let you introduce evidence about the conversation with the detective that related to the prior arrest.
Yes, sir.
Okay. What's your theory on admissibility of the conversation with the detective that related to the prior arrest.
It's so important because it supports the theory of defense here. Let's just assume for a minute.
But it, the state would make the same argument if they were trying to convict somebody for armed robbery by proving that the robber had done 20 armed robberies in the past. The evidence code draws some distinction when it comes to trying to prove that somebody acted in conformance with prior bad acts. Isn't this just prior bad acts evidence?
Let's just assume for a minute that what she's saying is true. She tells the officer, this was all a big misunderstanding before, I'm not a prostitute. If we assume for just a second that that is true, what are the odds, gentlemen, that this woman would be out at a hotel at 11 o'clock on a Sunday night on the trail with the same woman who caused her all this grief before?
Does the same rule of evidence apply to the defense that applies to the state as it relates to the proof that someone had acted in conformity with past behavior?
I don't think that that's the rule that's really involved here. It's the rule that says that the defendant gets to fully cross-examine the witnesses against him. And this victim has said something that I believe the jury would conclude is patently untrue. Now, you have to ask yourself, why would she do that? Why is it so important to her to have this officer and the jury later believe that she wasn't out there hooking that night? It's because it supports the defendant's theory that this was a consensual act. This was a robbery gone awry when this prostitute didn't get paid what she thought she was worth.
But you're
for her
not
services.
arguing the evidence code, you're arguing the right of confrontation.
Absolutely, and the right to present a full and fair
Did the judge
defense.
make the right ruling under the evidence code?
I believe he based his ruling on the rape shield statute, which has to bend and be superseded by the Constitution.
Was the ruling correct under the evidence code? In other words, is your sole argument the right of confrontation?
No, sir. I don't believe his ruling was correct. This isn't prior bad acts evidence.
Okay.
Counsel, you have 3 minutes.
This isn't harmless error, and the state felt the need to proceed to that level of analysis in this case. This prosecutor got up and argued in closing arguments within the space of just a couple of pages. My client, this victim, is not a prostitute, is not a prostitute, is not a prostitute. You've heard no evidence that she's a prostitute except for the defendant. About 16 times in a couple of pages here. This trial was not a full and fair presentation of the defendant's theory of defense. There has also been an argument that because of this mix-up with the paperwork, where when my client is apprehended in New York, he's apparently shown some papers that he shouldn't have seen. There's no evidence that the paperwork that he got would have allowed him to fabricate this defense after the fact. The record evidence is that within minutes...
Is that a point on appeal? I must have missed that. The one you're talking about.
I'm responding in the reply brief to the argument made by the state that this was harmless error because obviously the defendant's story is a big fabrication, and that was enabled by the paperwork that he received but shouldn't have received.
I would also say some rebuttal time. You want to say some rebuttal
I do.
time? Okay.
The last thing I would point out, there's record evidence, undisputed in this case, that my client told his mother in a telephone conversation within minutes of the occurrence of this that he'd gotten robbed and stabbed by a prostitute. There is no evidence of recent fabrication in this case, and I will reserve the last minute and 15 seconds or so for rebuttal. Thank you.
May it please the Court, Counsel, my name is Carmen Corrente, and I represent the Attorney General's Office in the state in this appeal. The record is also uncontroverted, if I may start off where we left off, that even though he told his mother that she was a prostitute, he told the police in New York when he was hiding in the closet that this was his girlfriend or ex-girlfriend and she was carrying his baby. She did not tell them that she was a prostitute.
That all has to do with harmless, whether it's harmless there, right?
Well, and if we're talking about that, but I mean, he has found some reason to change his story, and not that she wasn't a prostitute now, she was something else, she was a girlfriend. So His story at trial was very difficult for the jury to believe, given the fact that he used a brother's name or an assumed name at the hospital, that he hid, that he ran, and her story as to what happened in that residence is supported by much evidence. The 911 tape is a frantic call. The neighbor across the street...
Do you concede that the trial judge erred in relying on the rape shield statute to exclude the evidence?
No, not at all.
That? Why don't you tell me about that?
Well, the rape shield statute, we've all discussed it, we all know about it. The exceptions to it, though, are if consent is an issue and if you have to prove the consent. The problem in this case, and we have it in Carlisle, we have the exact scenario in Carlisle where the woman admitted she was a prostitute. She admitted even a lot more. She had recently accused another person of sexual battery, and they wanted to get that in as well. And the Carlisle case came down with the same result that you should do here, and that is that the evidence of prostitution and consent, it must be shown to materially hamper the defense in the case. The defense in this case wasn't materially hampered by not showing she was previously arrested. The entire trial was she was a prostitute, I was making a deal with a prostitute. He testified to that. She testified, no, I wasn't a prostitute. On that night, at that time. You cannot use a prior criminal accusation by someone as evidence that you were committing a crime this day.
Counsel, do you really believe that if they had been able to get into evidence the fact that she had been arrested for prostitution in the past, that the results of this case would have been the same?
Absolutely. I do, and that's because all of the evidence, all of that statement would then come in. And I don't think that from that evidence, they've proved from that statement, they've proven that she was doing it that night. You want to look at the facts? The facts are it has to be a pattern. What pattern we have in here? We've got the 751 of the incident where she was arrested. She's wearing high heels, a short, very short, it was described, jean skirt, a low-cut blouse, and she was walking the trail. In this, when she was 6 months pregnant, she has jeans on, flat shoes, sneakers. She's got 2 sweatshirts. It's cold. It's September, October, November, sometime in that period. And the facts are completely different. I think that any prosecutor could do very well, given all of the evidence that Mr. Rivers gave us in his own statement, his own testimony, where the inconsistent statements and the hiding and all of that, together with the fact that she wasn't walking that walk, she wasn't doing the same thing that she was then. I don't believe that it made any difference. The entire trial revolved around she was a prostitute, no, I wasn't. Even if she was a prostitute, when you get into that bedroom or the kitchen, or you get into the residence, something else happened there entirely. I mean, we have a blood trail. We have a nearly naked woman screaming for help, coming in, lock the door, he's going to kill me. If you're a prostitute, and if you try to rob somebody, I don't think the fact that you've just committed 2 crimes means that the first thing you're going to do is call the police. I think the first thing you're going to do is going to try to get out of there. I can't put myself in that position, obviously, but it's just something that I wouldn't surmise that that's what you do.
Was she actually charged with prostitution on the previous occasion? I mean, was the case malprost, or was she not charged at all?
I think she was charged with resisting arrest. She got into an argument with the police officer while they had stopped her for this. And I believe that was a resisting arrest. I believe that there was no charge ever filed or no bill.
Would that make any difference to the analysis, whether she was charged or not?
Pardon me?
Would it make any difference to the analysis whether she was charged?
No, I don't think it would, because still, even if you're charged with a crime, unless there's a conviction. And the judge here was even going to let them get in the fact that she was on probation, or so they thought. Turned out she wasn't. The judge was bending over backwards and allowing many of the things that we would consider more reliable, but just this accusation where they decided to proceed with a different offense, perhaps because it was easier to prove, perhaps it was because that's what she really did. Just because she gave it, we have a trial here.
Well, the issue here was whether or not she consented, right?
Right. I think whether she was a prostitute and consented.
Well, but I mean, the
Right.
The fact that she's a prostitute is only relevant if it bears on the issue of whether there was consent, right?
Right.
So,
If there was a deal.
he's arguing that his theory is that there was consent.
Right.
And that it was a prostitution transaction. It was a sex in exchange for money. And he got to introduce evidence of that, whether or not, that he got to cross-examine the victim on that point. He got to introduce direct evidence of that. All of that came out in the trial, is that right?
Exactly.
So really the second issue is, can he bulwark that, can he buttress that evidence by showing that she has a prior arrest for that?
And the answer is no. I think
Is there any case out there that in any context where there was it was permitted that evidence of a prior arrest be introduced to show that a victim or a defendant acted in conformance with that prior conduct?
Not that I have seen. The situation that you describe is exactly correct. The fact that she was a prostitute, if I want to say that, the fact that there was a deal going on still doesn't mean she consented. Yeah.
But he was not precluded from arguing that theory or introducing evidence or confronting her about that. Is that
Right. That argument that happened could have happened beforehand when she says, I want $150. He says, no, I'm only paying you $100. She says, no, I'm leaving. Take me out. We're not going to do this. And he forced and raped her. That could well have been exactly what happened. So that the prostitution part would have been correct. That still doesn't prove the crux of this case. We still have a jury issue here as to who was telling the truth. And it wasn't to be decided by going off on a mini trial about the victim, all in the details.
I was kind of most interested in counsel's argument that apart from the evidence code, under the constitutional right of confrontation, there may be some right to introduce this evidence. In other words, although you couldn't do it to a defendant, to prove that a defendant committed a burglary by showing that he'd been arrested 10 times before, maybe under the right of confrontation you can go outside the evidence code. Is there any authority on that one way or the other?
No, I don't believe that that's come up. I do know that my colleagues back at the office wondered if we should take the position in this that, well, yes, you should be able to. The state should also be able to do this.
Well, but counsel didn't argue that the state should be able to do it. Counsel argued that counsel argued that, because the evidence code cuts both ways.
Yes.
But the real issue is under the defendant's right of confrontation, does the defendant enjoy some rights that to introduce evidence that would not otherwise be admissible under the code? That's really...
Yeah, and I don't believe so. I know the Dosicle case that have been cited in the briefs, I know Judge Monaco was on that, and that case involved something that they wanted to get into evidence that she had, I believe she had, the victim in that case had said, I would never expect to sleep with a married man, or I would never expect a married man to do that, whereas the night before she had slept with a married man, and it was just the night preceding that. That was something that was reversed because that was very important to the case, and that was something that was very brief, and it involved her entire reason for this being how it ended up, how it ended up that she was a victim.
That's one of those probative value versus undue prejudice things.
Right. That's right. So, at any rate, Your Honors, if there aren't any other questions, I would strongly encourage this Court to realize that this is an abuse of discretion case. This was a judgment call by the trial court. It wasn't inappropriate at all. It was a reasonable decision. He was not prevented from cross-examining her about the defense, and he was able to present his case.
Thank you, counsel.
Thank you.
I'm going to talk as fast as I can and still be understood.
You have a whole minute and 19 seconds.
It's not just evidence of the arrest. It's the substance of that statement that she gave right after this alleged rape, which included at least the suggestion that she had been arrested. Here's what she said, and I quote at page 77 of the record. She told the dude, Rodelli, does it, but they said that I was trying to solicit to prostitution because I was telling that she had it.
She's explaining the prior incident, though, right?
Pardon me?
She's explaining the collateral incident.
Yes, sir. And it's
But
ridiculous.
if she was talking about a birthday party and lying about it to the policeman, it's still not necessarily relevant unless evidence of the birthday party comes in. In other words, you just can't introduce evidence of a conversation about a collateral matter for the sole purpose of impeaching the witness, can you?
I don't think this is a collateral matter, with all due respect. There is an adverse evidentiary ruling here that got aggravated in closing argument. 16 statements that there's no evidence this woman is a prostitute. The prosecutor even argued that the defendant's defense was absurd because setting a price before you get to the condominium is the way it's done. It's just not done the way this happened here. I would remind this court that according to this victim's statement to the detective, what got her in trouble in the first place was naming a price. I do think there is a case that settles this.
Counsel, your time is up.
Let me just ask one more question, if you don't mind.
Go ahead.
What's your best authority, your best precedent?
I will have to supplement with the correct site. I think Alaska is in the site, and it has to do with a fundamental precept of criminal jurisprudence in this country that the defendant can present his theory of defense.
All right, we'll find the case and look at it. Thank you.
Thank you.
All right, we're adjourned.